SJC-13080, Commonwealth versus Nickolas, Lacrosse.
Okay, Attorney Caddick.
May it please the court, Elizabeth Caddick for Nickolas Lacrosse. In this case, Mr. Lacrosse raised a mental health defense. That defense was supported by two expert witnesses, a neuropsychologist and a psychiatrist, who stated that he had an episode of dissociative amnesia at the time of the crime. This was supported by previous instances of dissociative amnesia by Mr. Lacrosse prior to this crime. There were witnesses who testified at trial and witnesses that the experts had spoken to personally. So in order to defeat this, the Commonwealth called two jailhouse informants. And what the jury was not told is that these jailhouse informants had previously made contradictory statements to investigators beforehand, and that they had collaborated with each other and had spoken about Mr. Lacrosse and the crime.
What do we do with the ineffective assistance argument where the very experienced defense attorney says, essentially what he said, I didn't want to beat a dead horse, you know, his words.
Right.
And he also says that and we look at the record, we have lots of impeachment of both these witnesses in multiple areas, and then we have the trial judge saying that what the trial lawyer did was reasonable. Okay. And you have a tough road to hoe for failure to impeach. So
I disagree. What the lawyer did was he impeached with their prior convictions, which is standard fare, and of course we know they're in jail, they have convictions. What he didn't do is impeach them with their contradictory statements that they had made before. And their statements at trial, which were different than their previous statements, were much more prejudicial, much more detailed, and now matched each other's testimony, whereas before they contradicted each other when they were speaking with investigators at different times.
When you say much more contradictory, did he cross-examine with prior inconsistent statements or at all, or just not to the extent?
He cross-examined them, but he didn't impeach them. What he did is he asked Gomez, well, you never told the investigators before that Lacrosse said he was going to play the crazy card. And Gomez said, oh, yes, I did. And the defense attorney didn't perfect the impeachment by asking the investigator who interviewed Gomez and had written the report, and it was in the transcript. So there was a written report and then a later interview that was on a transcript. He never said that. And so he didn't complete the impeachment by saying to the investigator who was there both times, well, he never said that Lacrosse was going to play the crazy card. So he may have questioned him about it. It was worse than if he hadn't asked it, because Gomez was allowed to self-corroborate and say, oh, yes, I did say it before. He did the same thing with Santiago. He had asked Santiago about whether he had said something before that was contradictory to what he testified.
Santiago had previously said he was going to play the crazy card, right?
Right,
Unlike Gomez, Santiago had actually made the point. He was testifying consistently on that point, right?
Right. And when he was asked a question by the defense attorney about, well, didn't you speak with Gomez about this, or he had asked him something that clearly he had said differently at trial, and Santiago said, oh, no, I had said that. And again, the defense attorney didn't perfect the impeachment by asking the investigator who testified later to confirm that the impeachment of Santiago. So he did not impeach the witnesses with their prior inconsistent statements, which is the most powerful way and really the only way to defeat the jury's belief that jailhouse informants are testifying truthfully.
Bert, where does that come from? What's that grounded in, that statement that you just made, that
Right.
juries generally believe jailhouse informants?
Absolutely. There's multiple areas of research that show that that juries believe jailhouse informants. Three main reasons. One is they believe they're already vetted by the Commonwealth. The Commonwealth would never put them on the stand unless they were vetted. The other is because they believe, even though they're told that they may have some consideration by the Commonwealth for their testimony, of course, they're never told they're going to have, definitely going to have some benefit. And so the jury believes what they say. Both of these jailhouse informants said what most jailhouse informants say: oh, I'm just doing it because I believe the crime was terrible and I'm doing it to help society, and not that they're doing it for selfish reasons. And the third reason is because jurors don't have the ability to detect deception any better than chance. And so they need the assistance of proper cross-examination, not just cross-examination, but proper cross-examination. And the other main reason that juries believe jailhouse informants is because they tend to have information about the facts that lend credibility to their testimony. But research has found that they generally get this information from other sources, either outside sources, and tell them what's in the newspaper, or from the defendant's own files. And we know here that Santiago stole.
I ask, the two main points you're making on this, right, are one, that Gomez testified inconsistently about playing the crazy card, and that Gomez and Santiago didn't talk to each other. They testified at trial, they didn't talk to each other, or I can't remember.
Right. Santiago said they didn't talk to each other at trial, but Gomez had said in his previous two statements, yes, Santiago and I spoke about Lacrosse's case.
So those are the two significant failures of cross-examination to you.
Well, I disagree, because at trial, the jury heard Gomez say, when Lacrosse slipped me the autopsy photo, he threatened me. He threatened me with my life. He threatened my life.
Correct me if I'm wrong, the conversation they had amongst each other with regard to the threat and the autopsy photographs, right?
Not just that, because what Gomez had said, that's what the Commonwealth said, but in fact what Gomez had said is that Santiago told him that he'd spoken with authorities about Lacrosse and the crime, and that they were going to talk to, what he said is, I spoke to the authorities about Lacrosse, about the photograph. The authorities and my lawyer are going to talk to you. Gomez had said, after the photograph incident, Santiago and I spoke, and that Santiago was outside my cell all the time. We spoke about Lacrosse and the crime multiple times. So the defense attorney didn't impeach Santiago with this. Also,
You don't have anything that suggests that they coordinated the playing the crazy card, right? That's the critical.
Oh, I do, because Gomez never said anything about the crazy
Does
card.
Gomez or Santiago ever say they both talked about playing the crazy
Well,
card?
no, they didn't talk about specifically.
Oh, but that's the main issue. That's the main purpose that it's significant, right?
I disagree, because you have one saying the crazy card, one not mentioning it at all, and then by the time trial comes, they have synced their testimony. And we know that Santiago had said initially to the investigators, I got the photograph from Gomez, and they later questioned Gomez, and Gomez said, oh, he didn't get it from me. I don't know how he got it. He probably got it from Lacrosse, because Lacrosse is always showing his discovery to people. But by the time the trial came, Santiago changed his testimony and said, oh, I got it from Lacrosse. because he had, okay, so then we have,
Kind of back to the
Yep.
question Justice Wendland asked you, are there other researchers besides this particular researcher who've made these points?
yes, yes, there's Natapov, who's she's now at Harvard, and she's produced probably the most research on jailhouse
And
informants.
she says that people trust them, despite the fact that it's obvious they're testifying for deals, they're
Right, because, first of all,
convicted felons.
right, and then you have Santiago denying, they didn't promise me anything. They only told me to tell the truth. They only told me to tell the truth. That's all I have to do. I'm not promised anything.
Yeah, but Santiago got all kinds of pending charges, right? Gomez may not, but Santiago has tons of pending charges. It's obvious he's got huge stakes in this, right?
Yes, but the jury still, research shows the jury still think, the only time that the jury will look at the jailhouse informants critically and find them unreliable is when it was pointed out to them that they had lied previously in this very case. Not that they were criminals, not that they, you might think that they
What was the sample size
for this.
for the research that you're concluding that juries generally don't believe
Right, well, but-
that jailhouse informants are lying unless they lie in the particular case?
Right, well.
What was the sample size for that conclusion?
Okay, there were multiple research articles that state
Right,
that
what was
they're
the
in
sample
brief.
size for that?
I don't remember.
Because
the
that's
sample size.
important
But, well,
to make a generalization like that, that juries generally believe jailhouse informants despite all of the things that Justice Kafka was referencing.
I agree, but this research was published in empirically validated journals.
Right,
So-
and so it may have been an accurate capturing of their particular sample size, but I'm just wondering how robust it is, and it sounds like you don't know.
Well, I don't know, but I mean,
That
I wouldn't
research
take the
include-
time, but
Does
the
that research include a champion instruction?
No, because the instructions don't work. There's also research
Oh,
that
so
shows the instructions don't work. The
The champion instruction's
No.
meaningless?
Well, yeah, because the
You should scrutinize with great care what this
Right.
person has to say?
Right, because it's not enough, and the research, they looked at the strongest jury instruction is in Connecticut. They had these mock juries, and they give them the scenarios, and then they give them this jury instruction, and it doesn't help them, whether they have the jury instruction or don't, the guilty findings are the same. It's only impeachment. And just to get back to, very quickly.
Before you leave that, though.
Yeah.
So he doesn't put in all this science, but is any court saying that the failure to put in this kind of jailhouse science is ineffective? Anyone around the country have?
No,
So are
no.
you asking us to?
I'm not
make-
asking-
Well, let me finish the
Sorry,
question.
I'm sorry.
Are you asking us to change the law here? Or are you asking us, what is it that's going to make this failure to introduce this science in this case ineffective? Is there case law out there? Because again, we have the Champa instruction, we have lots of other things here. Go ahead.
Okay. First of all, of course, I didn't argue that he didn't put the research in. I'm arguing he didn't properly impeach
Well,
them.
but without the research, it's not ineffective.
Well, I thought you, just to get the parameters, you're arguing two things. One is ineffective assistance of counsel for failure to impeach.
Right.
But you're also arguing that the judge erred in allowing the unreliable testimony into evidence.
I did not. What I argued is that,
you-
okay, what I argued was that it was an unfair trial to have unreliable jailhouse informants testify.
I was
and-
actually struck by your brief because it said it was inadmissible, and the judge erred by allowing unreliable testimony.
No.
Unless I read it wrong.
Oh, no, it was that the trial attorney knew for over a year that these jailhouse informants were going to testify. He knew what their statements were before. He knew their only purpose was to defeat his only defense, which was the mental health defense. And yet he still was not prepared to properly impeach them with their lies.
Because you said it was The introduction of unreliable jailhouse informant testimony was a deprivation of due process.
Right.
And then you give the factors, and then you go into ineffective assistance.
Right. And
I don't want to split hairs, the brief
oh,
says what it
okay,
says.
all right. And the motion judge had said that, well, it's up to, that, yes, the crazy card testimony was very powerful and helpful to, well, I don't know if he said very powerful, it was helpful, very helpful to the Commonwealth, but it's up to the jury to determine the veracity of witnesses. Well, the jury didn't have what they needed to determine the veracity of these witnesses. And on a 33E, this court looks at whether the defense counsel's failure to impeach could have had an effect on the jury's conclusion. Well,
Right,
it could have. We
it's-
have research that shows that.
No matter how we look at it, whether it's unreliable, your argument is it was ineffective, and you are saying that because of the inherent untrustworthiness of the informant testimony, it was overly prejudicial.
Right, and we know how prejudicial it was because of the research.
Right, okay.
Right, that's how you show prejudice.
Even though there were two expert witnesses on the other side saying that he actually did have an issue?
Well, there was one expert for the Commonwealth.
Okay, so,
Right, Dr. Fife.
okay, so,
Right.
but Rosemarin said that he had,
That he did not suffer from dissociative amnesia. She also said he didn't.
Five did.
Rosemarin's was
Oh,
your
Rossmarin
client's.
and Dieters had testified for Mr. Lacrosse.
Right, so
And-
two expert witnesses.
Right, oh, yeah, I'm sorry. Yeah, and they had well-founded opinions because of his prior instances, and they had done extensive testing.
So the
to-
jury had all of that information.
Right, but then, right, they did, and then they had the jailhouse informants come and say, oh, he said he was just going to play the crazy card. He hatched this up with his mother, and according to Gomez at trial, oh, he told me his mother hid the knife, and yet before, at the questioning, he said he didn't know what happened to the knife, and he was specifically asked, did Lacrosse tell you what happened to the knife? No, he didn't.
Can I ask, what is it that I understand what, on the failure to cross-examine Gomez, I understand your point on that, I'm not sure it's there, but what is there on Santiago that he could have used? Because Santiago testifies consistently that Lacrosse said he was going to play the crazy card.
Okay,
So
yeah.
what is it that should have been asked Santiago that wasn't?
Well, to show that he lied about how he obtained the photo.
So what? The photo doesn't deal with
It
playing the
shows he's,
crazy.
it
doesn't
shows
say-
he's a liar, is what it does. It shows he's a liar, and so then the jury can say. He initially, after asking multiple times to speak with the authorities at the House of Corrections, he was asked, what do you want to talk to us about? And he merely said, Lacrosse gave Gomez some autopsy photos. This makes me think he may have killed that girl. And yet, by the time he was interviewed 2 months later, he said, oh, I spoke with Lacrosse about the crimes 10 times, and he told me, and then he listed all these, and he told me he killed her, he told me he brought the knife with him, and I wrote all these notes down contemporaneously, right after he confessed to me, all these different times I wrote it down. He was never impeached with the fact that he didn't, after trying for multiple times to get in touch with the authorities, he never told Corporal Silva, oh, he confessed to me, he just said there was this photograph and it makes me think.
In the cross-examination of Santiago, does that get into the fact that he's like a professional snitch, that he's done this multiple times?
He wasn't the professional snitch.
It's Gomez.
Gomez was the
Is the
professional
professional?
snitch.
Okay.
Santiago had the written agreement.
I gotcha.
Gomez was facing jail time at the time he gave the statements. He was not facing.
Gomez was serving a sentence.
Yes, serving a
Santiago was
sentence.
pretrial.
Right. Exactly. Yeah. And I do just want to say that the mental health defense was worsened by the improper closing argument of the prosecutor, where she mocked without a basis the Dr. Rossmarin's, failure to say that he saw something on the video that he didn't, and arguing that he's just pretending he didn't see it.
I didn't
and
understand that argument. What was the? I didn't understand what the prosecutor was trying to do,
Yeah.
and so I don't have a basis for analyzing the effect.
Okay, so what the prosecutor tried to do during cross-examination.
Right, she showed him the video, says, "Hey, can't you
Can't you
see?"
see he's holding something in his hand?
And he says, "I don't know."
I can't make that out on that grainy photo. The objection was sustained. She tried to ask him that again. The second objection was again sustained. She argued it as if that was evidence that he.
Well, can't she just say to the jury, look at the video, if he's holding something, then he's not to be believed?
Right, but she mocked him instead and made it sound like he was he was denying seeing something that was so obvious when it's.
Was it her sarcastic tone that's the problem?
Well, what we know is that she also argued that same time that the two experts were pretending and not acknowledging that Lacrosse had lied to the police when he was being questioned afterwards, and they intentionally ignore all that because that's what they're paid to do. They're paid to give the testimony they gave.
But they were paid for their opinion, right?
Right, and so what she
I mean, we've said you can't say the word, the forbidden word is hired gun.
Well,
You can dance around it.
This was mocking them and arguing facts not in evidence, arguing that they never acknowledged that he lied when throughout their testimony they said, yes, he lied to the police, he was trying to hide the fact he committed the crime, but
That's relevant to the criminal responsibility test.
Right. So she's arguing that they're they're ignoring important evidence in order to give.
Right, but if you have an expert who chooses not to believe that someone is being deceptive, that they appreciate the wrongfulness of their conduct by being deceptive, isn't that fair game?
That's not what she was saying, though. She was saying they ignored that he lied to the police. She said he flat out lied to the police multiple times, and the experts ignored that.
Right,
They didn't ignore it. They explained why it had nothing to do with his mental state at the time of the crime, and why they determined that when he was talking to them and talking about his mental health history, that he was not lying because they did all these tests about whether he was malingering or not.
Okay, thank you.
Thank you.
Attorney Wendell.
Good morning. May it please the court, ADA John Wendell on behalf of the Commonwealth. Starting with the matter of the informants, our law is very clear. Informants are permitted to testify. They simply are.
Could you go through what was cross-examined on these informants and what was left out?
Well, so they're cross-examined, Gomez is cross-examined extensively regarding his memory problems that he has as a result of a head injury, his history as a professional snitch, the fact that he is actually at the time of trial in protective custody by the Commonwealth because of a threat from one of these prior instances of being a professional snitch. There's extensive discussion of his criminal history. He is questioned about making prior inconsistent statements. He denies having done so.
But there's no follow-up impeachment?
There is no follow-up impeachment specifically regarding those prior inconsistent statements with another. I do acknowledge that.
So that key statement that Gomez doesn't bring up the crazy card with the police officer, but then he testifies to it.
Yes.
That's not, there's no cross-examination on that point?
I don't recall what specifically was asked about that. in any case, he is questioned. He is impeached very heavily. He's not impeached specifically about prior inconsistent statements, except for the abortive attempt, but he is impeached. And our law is very clear, again, that failure to impeach at all is generally not ineffective. It is generally...
It depends. We have Commonwealth versus Ly, L-Y, and
Yes.
Commonwealth versus Lane.
Right. There are circumstances in which failure to impeach may be ineffective, but that is failure to impeach in any regard at all. Where an attorney undertakes impeachment, they are not required to impeach in a particular means by a particular manner. So because trial counsel impeached through use of the prior convictions, the prior criminal history, in Gomez's case, the lack of memory, and I'll note with Santiago, he was impeached through use of his own notes, which he said he had taken several notes regarding these conversations he had with the defendant. He was impeached with those notes, the fact that they didn't mention certain details. He was questioned, well, why doesn't it say this? Why doesn't it say this? It doesn't say that anywhere, does it? So he was impeached through use of his prior inconsistent
Right, but
statements.
they've upped the ante a little bit with the science. They're saying, okay, I mean, I haven't read these studies yet, but, so they're saying, okay, jailhouse snitches, despite sort of the obvious and despite Chiampa, are credited unless you show they're lying about the case. And here, there's something significant to have two different snitches who supposedly haven't talked to each other bring up the crazy card, right? But they have talked to each other, but there's no cross-examination on that, right?
They've talked to each other regarding the incident with the photographs. There's no evidence anywhere that they talked to each other about anything else. And
I've read her reply brief, and again, I haven't read the whole record
Right.
here, but
so
she suggests that Gomez, I think, says they talk all the time.
right. So,
Because, is that right or not right?
well, they do talk. There's no discussion of what they talk about. He merely says that they talk. He says that this is, excuse me a moment, page 187 of the record appendix. Question, then you had a conversation after Nick left. You had a conversation with Melvin. Answer, yeah. Response, okay. Further comment, me and Melvin usually used to always be by my door talking to me. That's, he's talking about how he speaks with Melvin Santiago on occasions. He then gets into a discussion of things that the defendant has told him, and then in the defendant's...
But doesn't one of them testify at trial? We've never talked.
No.
Okay, don't say that, because that's what her brief suggests.
They say, Santiago says, we never talked about the case. He agrees that they talked about the defendant, but he says they never really talked that much about the case, aside from this particular incident with the photographs.
You don't need to cross-examine the defendant, the person who's testifying to that help, but you talk all the time. And you see each other all the time, and you're both testifying in this case. So really? You never really talked about the crazy card before? I'm just asking.
There's a discussion of the manner of what they speak about, and they both agree that they speak about Lacrosse sometimes, that they spoke about the photograph incident, that Santiago warned Gomez that someone was going to come and speak to him about the photograph incident. All of that is brought out, and there's no evidence that they have ever talked about the case any further than that. And I'll note in the reply brief...
Even though they're both going to be witnesses, both going to be bringing up sort of the critical testimony that
Yes.
this thing is made up. They never talk about that.
There's no evidence for that.
But I know, but the cross-examination you still think is going to be adequate on this point, despite this. We'll get to the science later, but we don't have any cross-examination on that shows they did actually talk all the time, and this crazy card thing is made up for the first time not made up. Gomez brings it up at trial, even though he has not brought it up previously, or I can't remember Santiago, I may have them backwards, yeah.
Santiago did bring it up previously.
Yeah.
Yeah, the cross-examination, trial counsel expressed his opinion that there was really nothing else to do with these two because it was so obvious to him that they were so completely non-credible, he couldn't see how any juror could ever believe these individuals. And
Then that takes us to the science that, again, why don't you comment a little on the science? She's saying we've got multiple experts, I don't know the extent of these studies, that show that jailhouse snitches are credited despite instructions, although I don't know if they say despite instructions, unless they're shown to be lying in the case.
well, so the fundamental problem with that, the evidence that we have for that,
I'm just talking about the science. You want to address the science a little bit or no?
well, the only answer I can give regarding the science is that the only evidence we have regarding what the science is the testimony of Dr. Neuschatz, and Dr. Neuschatz' own credibility is in question. I cross-examined him extensively regarding his bias. He's uninformed. He stated that...
I don't know. I read, again, he's a professor where, sorry? He's a...
Alabama, Huntsville, Alabama.
He's at Alabama, Birmingham. He's published a bunch of articles.
Yes.
Just because he testifies always for the defense, he doesn't like jailhouse. He feels the science shows that jailhouse snitches are misunderstood. Isn't he testifying consistent with his science?
He's also uninformed regarding the law of Massachusetts. He has no idea what Ciampa says. He has no idea if his instruction that he gave in these experimental scenarios has any correlation to the Ciampa instruction, which was given in this case regarding Santiago. And I'll note regarding Gomez was not a cooperating witness, and Dr. Neuschatz believed he was.
I asked him about Ciampa. What did he say about Ciampa?
He said he was not familiar with it.
And I take it you read it to him. Is that the instruction he wants given or not?
I didn't actually read it to him. I asked him if he was familiar with it, asked him if he said there was something about Connecticut cases. I asked him which cases from Connecticut. He could not recall what the cases were from Connecticut. There was effectively no information at this hearing that we had regarding what instruction was actually given. So we don't know fundamentally from Dr. Neuschatz, even assuming that the trial judge was required to credit Dr. Neuschatz, which he was not required to credit Dr. Neuschatz. He had the right to discredit his testimony.
He didn't make a finding either way on that, right?
He didn't.
Judge Mason, he doesn't say anything about that. He just says the issue of credibility of snitches is for the jury, right?
Yes.
Which may be our law, as long as you give the Ciampa instruction.
Yeah, that is our law.
But she's got a two-part argument. She's saying, I think she's saying it was ineffective, I guess, not to bring up the science at trial and cross-examine consistent with the science.
Well, again, that goes back to the ordinary fallible attorney, and there is no clairvoyance requirement. He's going off of the law as the law is, and the law as it is that informants are permitted to testify, that credibility of any witness is for the jury. We do not have credibility hearings to determine preliminarily whether the witness is testifying credibly, and impeachment may be done by any of a number of means and is a strategic decision left to trial counsel.
Can I ask about, I don't know if you've done, can I ask about the closing argument?
Yes.
There was one portion of the closing argument that seems problematic. The cross-examination of the defendant, he testifies to this disassociative period, and he snaps out of it at one point after the murder. Mm-hmm. And then when he appears on the surveillance tape.
Yes.
And the prosecutor says, well, something like, well, isn't that convenient? It matches the video. And the problem with that is the inference that the defendant, who has a right to be present at trial, is tailoring his testimony to the trial evidence.
Right. The tailoring, the requirement that we avoid arguments about tailoring we're allowed to make that argument if there's an evidentiary basis for that. The cases where tailoring is said to be improper is where there is no evidence that the defendant had access to the discovery prior to trial, where there's no evidence that the defendant's statement has modified over time. Where there is evidence that the defendant had access to the discovery, which they're both Dr. Fife and Dr. Rosmarin testified that, yes, the defendant had access to the discovery in this case prior to speaking to us. Where there's evidence of that and evidence of the statement modifying over time, we are permitted to argue that the defendant has tailored his testimony in some respect.
Modified over time, because the only other statement he gives is the one to the police where he denies everything.
He gives fundamentally, I would say, 5 statements that are at issue here. He gives the statement to the police, which itself modifies over the course of the interview. He starts with, I wasn't there, I haven't seen her in weeks, I shaved 3 days ago, I don't know what you're talking about, what do you mean you saw a video of me with a beard? Then later on he admits that, oh no, actually, I shaved this morning. So he changes his statement while speaking to the police. He then gives statements to the 3 experts, and those statements are themselves different from each other. And then he gives a slightly modified variation again at trial. So he gives fundamentally 5 different statements, and there is evidence between the first statement to the police, the later statement to Dr. Fife, and then ultimately his statement at trial. There is evidence that he is modifying his statement and making it more self-interested and in some respects more consistent with the discovery. So the argument of tailoring is permissible in the particular circumstances. And I'll just briefly mention with regard to the argument that the experts are ignoring evidence. There are multiple instances.
Before you leave, Justice Gaziano's thing, I'm not sure I understood how he conforms to the video. Explain that a little bit. I just couldn't follow it.
Well,
So, yeah.
He initially makes the statement, I wasn't there, I had, I was 2 miles away. I had nothing to do with this. I have no idea what you're talking about. I was home.
But there's something particular to the timing of the video. He does something in the video, and then his testimony, I just couldn't follow it.
The statement that he makes is that he leaves, wakes up, if you will, on the corner, realizes that something terrible must have happened, and goes back inside.
To pick up the knife.
Well, that's the statement to Dr. Fife is, I went back in to pick up the knife. The statement to the other experts is, I went back in because I thought something terrible must have happened.
And when the prosecutor in closing is talking about the video and how he modifies his testimony to be consistent with the video, what is the prosecutor saying?
Well, what she doesn't actually say he's modifying his testimony to be consistent with the video. She says, he gives this statement, doesn't that just fit so perfectly with the evidence that we have here, which I don't recall, I apologize, I read it yesterday, I don't recall her specifically referencing the video. She just says, isn't this so convenient, doesn't it match the evidence so perfectly? Remember, Dr. Fife told you he had access to the evidence before trial, which that's an argument that it's very convenient the way that his testimony now, which is drastically different from the statement that he made to the police, meshes with the Commonwealth's evidence, and hey, he had access to that evidence prior to trial. He knew what we were going to present. You heard testimony that he knew exactly what we were going to present. So there's actually no direct argument that he's modifying his statement. It's an argument that it's convenient and it meshes, which is permissible in the circumstances. So just briefly, regarding the 2 experts and the argument that they're ignoring evidence, that's a fair argument in the circumstances. There are multiple things that they say that amount to, I chose not to factor that into my decision.
It's an argument about cherry picking, essentially.
Yes. So, for example, Dr. Dieter's pages 125 to 126 of the May 16th transcript, He's asked whether he asked the defendant where he ever got the knife from, and he says, no, I didn't think it was relevant.
What about the testimony or the argument about the defendant having something in his hand where the questions were sustained? So they were sustained, they didn't come into evidence,
The
correct?
objections were sustained as to the questions. You didn't see him carrying anything. But he's asked, did you notice his hands? And he says, no, I didn't notice anything about his hands. And I know the court has a copy of that exhibit. It was transferred. The defendant's hands are, with all due respect to the expert, the most noticeable thing about that video. Initially, his hands are up, then they're down by his sides, and then they're up again later in the final clip. So
The inference that he's carrying the knife?
that would be a permissible inference. That is the inference that my colleague argued, certainly. There's evidence that he's carrying something away. Oh, I didn't notice anything about his hands, is the statement. And his hands, they start up, then they're down, then they're up again.
Why was the objection, why were the questions sustained?
I think in the circumstance,
Isn't it asked and answered a couple of times, and then the judge gets fed up? I thought you
that is part of it. I think there's also an argument being made by the defendant, that by trial counsel, that this is a characterization which we're permitted to make that characterization in closing argument, but aren't necessarily permitted to do that in questioning a witness. I honestly don't. I read that and I don't know what the basis for sustaining that objection was, to be honest. I think it's because it's improper characterization.
Of a video?
Of the video.
Improper narrative of a video?
That would be my understanding of the basis for the objection that was sustained. I see I'm nearly out of time unless there are any further questions.